1A and B of Section 124 of the Electoral Act also require that the alleged bribe be given or offered to a voter. Therefore, it becomes necessary that the name of any of the voters whom the witness saw bribed must be given evidence. This is to ensure that the corrupt practice of bribery was actually effected on a registered voter or voters not at large for the purpose of illicitly swaying the voters' free choice of candidate in the election in order to maintain a sanitized electoral process that will be seen to be conducted in a free and fair manner and on level playing ground. There is no convincing evidence that the alleged bribe givers acted with the knowledge and consent of the second to third respondents or with the knowledge and consent of a person that acted under the general or special authority of the second to third respondents with reference to the election as required by Section 124, Subsection 6 of the Electoral Act, which, for emphasis, states that a candidate will only be held responsible for bribery or if the offense was committed with his knowledge and consent or the knowledge and consent of a person who is acting under the general or special authority of the candidate with reference to the election. Clear and unequivocal proof of allegation of bribery was also not made out by the petitioners, as it is not sufficient to suggest that the mere fact that somebody else bribed other persons to vote for a particular candidate was enough and conclusive evidence against a candidate in an election, as such a candidate cannot be held responsible for what other people did in the form of unsolicited aid or which he or his acknowledged agents were ignorant. See, Anazodo against Audu, citation supplied. There was therefore lack of concrete evidence to establish that the second and third respondents personally committed a corrupt act of bribery or aided, abetted, or counseled, or procured the commission of the alleged corrupt practice of bribery. Nor was it established that the alleged act of bribery was committed through an agent that was expressly authorized to act in that capacity, or granted the general or special authority to act in that capacity on behalf of the second and third respondents. Nor did the petitioners establish that the alleged corrupt practice of bribery substantially affected the outcome of the election to warrant nullification of the election of the second respondent, whether Section 139, Subsection 1 of the Electoral Act, and the cases of Auda against INEC, Buhari against Obasanjo, Abubakar against Yaradua, Oke against Mimiko, Akeredolu against Mimiko, Ngige against INEC, all citations applied. The Pt.4, the Kenyan witness, admitted he obtained the information contained in his P87, P88, P89 from a whistleblower's website which had hacked, permit the colloquialism, the website of the first respondent. The bottom line is that the information and data upon which the Pt.4 based its analysis of the results of the election contained in exhibits P87, P88, and P89 were sourced from the website of the first respondent, a public body, by means of hacking its website by a whistleblower. The website of the first respondent is doubtless a document within the meaning of Section 258, Subsection 1 of the Evidence Act, which defines document as any device by means of which information is recorded, stored, or retrievable, including computer output, end quote. Proceeding on the footing that the ultimate source of the information and data contained in exhibits P87, P88, P89 were illegally obtained from the website of the first respondent, the computer printout of the information and data in P87, P88, and P89 should have been certified by the first respondent, a public body in custody of a public document, as secondary evidence under Section 102, 104, and 105 of the Evidence Act as amended. Exhibit P87, P88, and P89 were not certified, therefore they have no evidential value. See Kobo and another against Dixon, certificates applied. Per the lead judgment prepared by His Lordship Onogan, JSC, letter CJ, and thus, I quote, the fact that the exhibits are computer printouts or e-documents does not change their nature and character as public documents. His Lordship Ogumbi JSC had this to say in his judgment, I quote, also on the same footing is the document exhibit L, which is a computer or internet-generated document allegedly printed by the appellants from the website of the third respondent. as rightly submitted on behalf of the respondents by virtue of Section 102, Roman 2 of the Evidence Act, such document is classified as public document and only a certified true copy of same is admissible in evidence. It follows, therefore, that the two exhibits D and L share the same fate and are rendered of no legal effect. The lower court was therefore on sound footing in upholding the tribunal stand by expunging these documents. The following authorities are relevant in support: NIPC Limited against Thompson Organization Limited, Kankia against Megemu, and then Owunia against Omotosho, all contained in the quotation. Besides, the Pt.4 admitted that information or data upon which the expert evidence is in course, his base was hacked by a whistleblower from the website of first respondent, from whose website the witness derived the information and data that formed the basis of his analysis, containing exhibits P87, P88, and P89. Sections 14 and 15 of the Evidence Act, as amended, state, quote, evidence obtained A, improperly or in contravention of law, or B, in consequence of an impropriety or of a contravention of law, shall be admissible unless the court is of the opinion that the desirability of admitting the evidence is outweighed by the undesirability of admitting evidence that has been obtained in the manner in which the evidence was obtained. 15. For the purpose of Section 14, the matters that the court shall take into account include A, the probative value of the evidence, the importance of the evidence in the proceeding, that is B. C, the nature of the relevant offense, cause of action or defense, and the nature of the subject matter of the proceedings. D, the gravity of the impropriety or contravention, and E, whether the impropriety or contravention was deliberate or reckless. F, whether any proceeding, whether in bracket, whether or not in a court, end bracket, has been or is likely to be taken in relation to the impropriety or contravention. And then G, the difficulty, if any, of obtaining the evidence without impropriety or contravention of law, end quote. The website of the first respondent from which the information that was hacked, being any device by means of which information is recorded, stored, or retrievable as a computer output, is the document under Section 258, subsection 1 of the Evidence Act, which should have been accessible to the petitioners for inspection for the purpose of filing and maintaining the election petition under Section 151 of the Electoral Act, empowering the court to order for inspection of electoral documents and or any other documents in the custody of the first respondent. See Latoja against Ajimobi, petition supplied. Consequently, the petitioner had no basis to subtract the law by benefiting from the hacked website of the first respondent through the machination of the whistleblower, thus resorting to self-help, which the Supreme Court deprecated in the case of Governor of Lagos State against Ojukwu, citation supplied. The law also frowns at a party benefiting from a wrongful act. Further, in the case of Totti and Opabi, against Opabi, citation supplied, the Agolo DSC expressed reservation on placing weight on evidence obtained by felonious means or by breaking the law, as in this case. The criminal case of Sadao against the state following pre-counsel case of Kruma, son of Kani, against the Queen on the propriety or illegally obtained evidence by way of illegal search of an accused person are to be appreciated against the background that criminal law is addressed to all and sundry and is for the protection of society in the pursuit of which the state and the citizenry are stakeholders. Therefore, incriminating relevant evidence found on an accused person by illegal means will meet the ends of justice or ground of overriding public interest for the protection of society by the state using the illegally obtained evidence to prosecute the accused, whose remedy may lie in a civil action for damages against the state for the illegal search. In the present case, the petitioners deliberately and recklessly relied on the hacked information and data in question when it would have been convenient for the petitioners to have followed due process under Section 151 of the Electoral Act to inspect the document and obtain certified true copies thereof. At the time, the first respondent's website was hacked before the petition was filed. Thus, breaches Section 15 of D, E, and G of the Evidence Act. Based on the discussion supra, I respectfully place no weight on exhibits P87, P88, and P89 as they are a product of unjustifiable and illegally obtained evidence by means of hacking the website of the first respondent by the whistleblower using his website, through whom the P.4 improperly obtained the information and data contained in exhibits P87, P88, and P89. The P.60, the statistician, is not competent to analyze and produce report or editing results and alleged malpractices afflicting them, though presented as an expert witness. His evidence on documentary analysis of the electoral documents contained in exhibits P98 to P90J, therefore, have no evidential value. See Ladoja against Ajumobi, Supra at pages 142 to 144. I quote Ogumbi JSC there. I'm quoting, PW1's report or inspection is replete with analysis of election materials, and at the end of each table, he gave analysis and opinion and conclusion of the materials analyzed by him. This is evidence at pages 4397 and 4398 of volume 5 of record reproduced earlier in the course of this judgment. The analysis of the smart card reader accreditation, PVC, collected and votes cast on each table in each local government is made from pages 3611 through 4371 of the volume 5 of the record. The witness, PW1, is also not qualified to analyze or subject to forensic scrutiny electoral forms, results, and documents in the manner he did. In the case of Buhari against INEC, statistics supplied on a somewhat related matter, the Court of Appeal, without much ado, rejected the appellant's report because he was not qualified to analyze INEC documents. The lower court, at pages 386 to 389 of the report, wasted no time in rejecting the documents. Also, in the recent decision in AC 409/2012, our Shell Congress gave Rear Admiral Murutala H. Nyako and others delivered on November 12, 2012, reported in 2012, APELR 19649 SC or 2015, 18 NWLR Part 1491, then page 352. This court, in a similar situation, rejected the evidence was statistical analysis of a witness who described himself in his statement on oath as a graduate of economics, a consumer banking officer, and a retail financial analyst, and head thus. They're quoting the PW66 by qualification and learning is not an expert in the art of establishing multiple registration and voting elections, special skill in respect of which would have been entitled him to assist the tribunal to form his opinion on the point, end quote. See also the case of NPP against Osman, citations supplied, where the judgment prepared by his lordship Aboki JCL. The RW4's attention was drawn under cross-examination by the petitioner's learned senior counsel to the first name, quote, Mohammed, end quote, on Exhibit R19, the Cambridge Assessment International Education Certifying Statement, while the first name of the second respondent in the petition is, quote, Muhammadu, end quote. There should be no fuss over the name Mohammed and Muhammadu, because as held by the court, that is Koran Msofo, Ikongbe, Onogen, Mikaelu, Nwuta, JJC in Alliance for Democracy against Fayoshe, the citizens supplied per the lead judgment prepared by Msofo, JCA does, I quote, and I ask this, what really is in a name or a name? Cuculus non facit monachum. Now, name derived from Latin nominis in its noun form, see Chambers 20th Century Dictionary, page 875, is defined to mean, quote, that by which a person or a thing is known and called, a designation, end quote. Of the big quote continues. Of what concern or to whom does it matter if a chooses to be called or known by many names or very many names? I confess that I know or no legislation or a decree in Nigeria restricting the persons to a number of names he may be called or known by no such law, end quote. It is therefore not in doubt that the document exhibit R19 bearing the name Muhammad Buhari refers to one and the same Muhammad Buhari, the second respondent in the petition. In the result, I too concur that the petition has not been proved as required by law and deserves to be dismissed, and hereby dismiss it and abide by the consequential orders contained in the judgment pronounced by my learned brother, Garba JCA.
My learned brother to my extreme right will now pronounce his own decision in respect of this petition.
Well, I agree with the conclusion contained in the legal judgment as per the fate of this petition. The facts are well spelled out therein, and I do not intend to repeat them. However, I deem it expedient to further address the issue of whether or not there existed a server for use by the first respondent, as well as the relevance of smart card readers during the 2019 general elections. The petitioner's stance is that by their utterances, news briefings, and the manual, as well as guidelines for the conduct of election, it is not in doubt that the first respondent intended to and did make use of smart card readers and the server for the electronic transmission of election results during the 2019 presidential and National Assembly elections. The law is right that he who asserts must prove such assertion. See Section 1361 of the Evidence Act 2011. See also Awuse and Odili, Mogaji and Odofin, Elias and Omodare, Daudu and NMPC, with citation inclusive. In Adigije and Nwogu, this court, Ogumiju JCA, held that, and I quote, Section 137 of the Evidence Act 2004 provides that for a burden of proof in civil cases, the burden of first proving the existence or non-existence of a fact lies on the party against whom the judgment of the court will be given if no evidence were produced on either side, regard being had to any presumption that may arise in the pleadings. If such party adduces evidence which might reasonably satisfy a court that the fact sought to be proved is established, the burden lies on the party against whom judgment will be given if no more evidence were adduced, and so on successively until all the issues in the pleadings have been dealt with, unquote. See also M.O. Kanu and Sons against Nzeribe with citation, Abaji, JCA, then now JSC. The quotation is here, but I do not intend to, it's taken as having been read. The petitioners herein are pleaded in paragraphs 26 to 29 of their petitions as follows, and they said they are quite extensive, but I will take them as having been read. The first respondent in response averred in paragraph 15 and 16 of the first respondent's reply to the petition as follows. I also detail the averments of the first respondents in my own contribution. In the light of the above set out averments, there is no doubt that issues were strongly joined on the existence or non-existence of a central server and whether the results of the presidential election, which held on the 23rd of February 2019, was electronically transmitted. The petitioners in support of their pleading in this regard called PW2, PW3, 4, 12, 16, 17, and 36. The evidence are inclusive here. PW2 testified that he was an ad hoc staff of the first respondent, and he worked as registration area technician RATEC and ward collation officer for Ward 5, Constituency 2 of Ogbaegbe Mandoni local government area of Rivers State. He stated that before the election day, he was trained by the first respondent, INEC, on the use of the smart card reader at the election. The smart card reader was to be used at each polling unit for the mandatory accreditation, verification, authentication, collation, and transmission of results of the election. And that apart from one polling unit in the ward, where there was a snag The smart card was used in all the other polling units for accreditation, verification, authentication, and collation of results of the election. He, however, admitted under cross-examination that he did not function as a presiding officer or assistant presiding officer. Pt.4 also was an ad hoc staff of the first respondent who testified that he was employed as a presiding officer, PO, at the Civic Center Amoji polling unit with code 005 in Amoji Ward in Enugu East Local Government Area of Enugu State. He added that he was trained by the first respondent on the mandatory use of smart card readers for authentication, collation, and transmission of results of the election at the polling units, and that upon conclusion of voting and collation of results, he transmitted the results of the polling units electronically to the first respondent server using the code or password provided by the first respondent and as directed. He, however, stated under the cross-examination that he was not told the name or number of the server, but all he knows is that he transmitted the results to a server. Pt.4 also gave similar evidence on the use of smart card reader at the election, as he deposed in his statement on oath that he electronically transmitted the results of the election into the server belonging to the first respondent using the code or password as provided. He agreed also during the examination that he did not state the number of the smart card or server location in his statement on oath. Pt.12 testified also that he was a polling agent for the petitioners in Tanko Kutawan polling unit of Chanchaga local government area of Niger State. He stated that in his polling units, election commenced with the use of smart card readers, which later broke down and resort was had to manual authentication of voters on the directive of the presiding officer. Pt.16 also testified that he was an ad hoc staff of the first respondent and worked as Assistant Presiding Officer, APO, for Wako Polling Unit 001 in Kwali, local government area of the Federal Capital Territory. He stated that the election was conducted by a smart card reader, and the result of the election was transmitted electronically to the first respondent server using the code also provided by first respondent after verification by the respondent's area technician. He also stated under cross-examination that though he transmitted results to the servers, but the server number was not given to him. Pt.17 equally in his statement of oath deposed that he was the first respondent ad hoc staff during the election at an APO. He was engaged as an APO at the local LEA primary school, Galadima/Gwarempa polling unit, FCT, where the card reader was used for accreditation, verification, authentication, collation, and transmission of votes through the first respondent server by the code provided by first respondent. He also stated during cross-examination that he was told during training that the server belonged to the first respondent, though he was not given the server number. Lastly, Pt.36 testified as evidence also that he was an ad hoc staff of the first respondent during the election, and he functioned as area presiding officer, APO1, where he used the smart card reader in his polling unit and equally transmitted the election results electronically to the first respondent server via the smart card reader. His response during cross-examination was that he was trained to transmit results to INEC, and although he did not personally see the server, he was told about it by the first respondent. On the other hand, the first respondent did not call any witness to support their pleadings in this regard, but rather opted to rely on the petitioner's case via the evidence elicited during cross-examination. The second and third respondents also did not call any evidence to support or deny the existence of the first respondent server, which is very clear. Though I'm not unmindful of the tri-state of the law, that a party can rely or rest its defense on the evidence given by a claimant during cross-examination. But this is premised on the condition that such evidence must relate or derive from the facts averred to in the pleadings. The bottom line here is that neither the first respondent specifically nor the second and third respondents called any evidence to add life or flesh to the facts in denial as averred in their pleadings, with regard to the use or non-use of the smart card reader or server. The law is long settled that where issues are joined on any averments, but no evidence is laid to support such, the end result is that such averments are deemed abandoned and prone to be struck out. See Omoboreo and Ajasin, Magnuson and Koiki, Cameroona Line and Otutu with citation inclusive, also Odunsi and Bambala, and Amechi and INEC. On this premise, the position of the law is succinctly stated by the Supreme Court. Aloma Mukhtar JSC, later CJN, now retired, in the case of New Breed Organization Limited against Eremosele, 2006, 5 Nigeria Weekly Law Report, part 974, at page 499, as follows. Quote, when a defendant refuses to adduce evidence in his defense and rests his case on the evidence of the plaintiff, then he has himself to blame if the trial court finds for the plaintiff based on his evidence as was done in the instant case. The position of the law is that where an adversary fails to adduce evidence to put on the other side of the imaginary scale of justice, a minimum evidence adduced by the other side will suffice to prove its case. See Braimo and Bangboshe and Mwabuoku and Otis, with citation, unquote. In the instant case, the respondents, as particularly the first respondent, refused or neglected to adduce evidence on the vexed issue of whether or not smart card readers were used during the 2019 elections, or that there exists a central server, but opts to rest their case on the evidence as adduced by the petitioners. The consequence is that there is no other evidence to put on the other side of the imaginary scale to judicially weigh the evidence on both sides of the divide. It follows, therefore, that the evidence as adduced by the petitioners in support of their pleadings, as earlier detailed, will be taken as sufficient proof that smart card readers were used during the presidential election, which held on the 23rd of February 2019. What is more, Section 15.2 of the Electoral Act 2010, as amended in 2015, states as follows. 15.2, I quote, voting at an election under this Act shall be in accordance with the procedure determined by the Independent National Electoral Commission, unquote. Pursuant to the above provisions, the first respondent introduced Exhibit P27, that's regulations and guidelines for the conduct of elections, and Exhibit P28, Manual for Election Officials 2019, also Exhibit P33. The sex exhibit contains rules and regulations to guide the first respondents officials in the conduct of the elections. And this includes the use of smart card readers to verify permanent voters' card and authenticate before voting, as shown in paragraph 8B of Exhibit P27. Other relevant paragraphs are 10, 13, 28, and 29. The same goes with chapters 1, 2, and 3 of Exhibit P28, which contains specific procedures to be adhered to before, during, and after close of voting, as well as transmission of results and accreditation data using the smart card readers. That said, I am, however, not oblivious of the present state of the law as enunciated by the Supreme Court in Yesomwike against Peace Aside, 2016-7 Nigeria Weekly Law Report, Part 15-12-452, or 2016 LPLR 40,036 Supreme Court, wherein Kekere Kun JSC stated as follows, and I quote, I had stated earlier in this judgment that INEC is to be commended for the innovation of the card reader machine to boost the transparency and accuracy of the accreditation process, and to maintain the democratic norm of one man, one vote, by preventing multi-voting by a voter. Nonetheless, Section 49(1) and 2 of the Electoral Act 2010 as amended, which provide for manual accreditation of voters, is extant and remain a vital part of our electoral law. The section provides us, any person intending to vote with his voter's card shall present himself to a presiding officer at the unit in the constituency in which his name is registered with his voter's card. 2. The presiding officer shall, on being satisfied that the name of the person is on the register of voters, issue him a ballot paper and indicate on the register that the person has voted. In the recent decision of this court in Shinkafi and Yari Supra, Okoro GSC stated thus: my understanding of the function of the card reader machine is to authenticate the owner of a voter's card and to prevent multi-voting by a voter. I am not aware that the card reader machine has replaced the voter's registrar or has taken the place of statement of result in appropriate forms. Again, where the JSC, Nokereke and Umahi and others, unreported Supreme Court 1004/2015, delivered on the 5th February 2016, reiterated the position as follows, quote, indeed, since the guidelines and manual, Supra, which authorize the use and deployment of the electronic card reader machine were made in exercise of the powers conferred by the Electoral Act, the said card reader cannot logically depose or dethrone the voters' registrar whose juridical roots are firmly embedded or entrenched in the self-same Electoral Acts from which it, bracket, voters' registrar, directly derives its sustenance and currency. Thus, any attempt to invest it, that's the card reader machine procedure, with such overreaching preeminence or superiority over the voters' registrar is like converting an auxiliary procedure into the dominant procedure or proof that is proof of accreditation, unquote. That's Perekereku. See also the case of Emmanuel Udom and Umana, number 1, 2016-12 Nigeria Weekly Law Report, part 1526-179. The quotation is there, is quoted part of the judgment there. Also, their Lordship Roseviver GSC also addressed the issue at page 86 and 87 of the same report. And in INEC and Peter side, Mohammed JCN, as it then was also stated, and I quote, however, in the present case, the first and second respondent petitioners only relied on the second leg of paragraph B of section 138(1) of the Electoral Act 2010 as amended to claim that the election in Rivers State was invalid only for failure of the officials of the appellant to comply with the appellant's order on them to use smart card readers for accreditation of voters for the election, which the respondent petitioners failed to relate to any provisions of the Electoral Act to qualify as non-compliance with the provisions of the Act. In this regard, I am of the view that the first and second respondents / petitioners failed to prove their case at the election tribunal, that the failure to use smart card readers for accreditation of voters at the election had the effect of nullifying the entire election in Rivers State, unquote. Okoro JSC also made its own contribution, and the same with Sanusi JSC, the portion of which are reproduced in this contribution. I also refer to the case of Shinkafi and against Yari, 2016 LPLR 26050 Supreme Court decision, where the Supreme Court stated that the function of smart card reader is solely to authenticate the owner of the voter's card and to prevent multi-voting by a voter, and cannot replace the voter's register or statement of results in appropriate forms. See also Ogboru and Okowa, 2016-11 Nigeria Weekly Law Report, part 1522-84 at 129 per Okoro JSC. And I set down the quotation, the portion of the judgment here. In the light of the above set out decisions, which represents the extant law vis-a-vis smart card readers as a means of proving non-voting, overvoting, transmission or non-transmission of election results, the issue of smart card readers in the present discourse serves only the purpose of helping to improve the accreditation process during election, and as such complements the procedure set out in section 49 of the Electoral Act 2010 as amended, which provisions, I dare say, does not include recourse to a central server for the purpose of collation or declaration of election results. This point finds expression in section 63, 65, 69, and 74 of the Electoral Act 2010 as amended. Section 63 provides, said, the presiding officer shall, after counting the votes at the polling unit, enter the votes scored by each candidate in a form to be prescribed by the Commission as the case may be. 2, the form shall be signed and stamped by the presiding officer and countersigned by the candidates or their polling agents where available at the polling unit. 3, the presiding officer shall give to the polling agents and the police officer where available a copy each of the completed forms after it has been duly signed as provided in subsection 2 of this section. And 4, the presiding officer shall count and announce the result at the polling units. Then section 65 said, after the recording of the result of the election, the presiding officer shall announce the result and deliver same and the election materials under security to such persons as may be prescribed by the Commission. Then 69 said, I quote, in an election to the office of the President or Governor, whether or not contested in any election to any other elective office, the result shall be ascertained by counting the votes cast for each candidate and subject to the provisions of section 133, 134, and 179 of the Constitution. The candidate that received the highest number of votes shall be declared elected by the appropriate returning officer. Then section 74 concludes. He said, every result form completed at the ward, local government, state, and national levels in accordance with the provisions of this Act or any guidelines issued by the Commission shall be stamped, signed, and countersigned by the relevant officers and polling agents at those levels, and copies given to the police officers and the polling agents where available. The resultant effect of the above set out provisions is that collation of results are to be done manually, and declaration of such results are to flow from the figures as entered in the relevant forms at the various levels of collation. It is not dependent on the content or use of a smart card reader for the transmission of election results. Hence, section 74 specifically provided that every result form completed at the polling units, ward, local government, and states and national level shall be stamped, signed, and countersigned by the relevant officers and polling agents at those levels, and copies given to the police officers and polling agents where available. Albeit, and for the purpose of posterity, the first respondents have the interests of the generation now and generation next. I will emphasize again that to all intents and purposes, the law requires or mandates the first respondent to operate a website under section 71 of the Electoral Act, which provides as follows, and I quote, the Commission shall cause to be posted on its notice board and website a notice showing the candidates at the election and their scores, and the person declared as elected or returned at the election, unquote. The above set out provisions use the word shall, which connotes mandatoriness or command. See Shetima and Goni, and Oba and Suswam, as well as Onochie and Odogun with citations. Furthermore, the posting of the results must be on the notice board and website. The word "and" is conjunctive, which means that the result must not only be posted on the notice board, but also on the website. A website is defined by the English Dictionary Online Edition as, quote, a computer connected to the internet that maintains a series of web pages on the World Wide Web, unquote. It also defines a server as a digital computer that provides workstations on a network with controlled access to shared resources, unquote. In the light of the above clarifications, it will not be out of place to emphasize that as a fact duly proved as earlier indicated, and by law, as per the Electoral Act 2010 as amended, there exists a website managed and controlled by the first respondent. The above clarification, however, notwithstanding, I also hold that the petitioners did not adduce sufficient evidence to justify the grant of the relief sought. Thus, the petition is also hereby dismissed, and I abide by the consequential orders made in the late judgment, including the order as to costs.
My learned brother to my extreme left will now pronounce his own decision in respect of this petition.
I completely agree with the comprehensive and incisive judgment delivered by my presiding justice, M.L. Gabra, PJCA, as it contains enough details to show that in all respects, the petitioners have failed to establish or prove any of the relief sought by them, either in the main or in the alternative.
Gentlemen, we have noticed several errors that are contained in the judgment which I delivered. We shall undertake corrections of the judgment and then give parties copies, clean copies after the corrections.
My Lords,
yes, Dr. Udoku.
my Lords, may I start by commending your Lordships for the industry exhibited in the rulings and judgments delivered today, lasting, by my calculation, for a little over 8 hours. I sincerely believe that this must be the longest sitting of any court in this country and the longest judgment in the annals of jurisprudence and judicialism in this country. My Lords, let me also thank my Lords for the opportunity given to us to present our case, and also commend my Lords that the petition at least was not allowed to expire, because that is very, very important to us as petitioners, and we are grateful.
You're welcome.
My Lords, having said this, my Lord, the presiding justice had already promised that in the shortest possible time, we will get the rulings and judgments.
Yes, you will.
In the next 24 hours.
We shall get the corrections made soonest, as soon as possible.
As court pleases.
It's even better in our own interest to get finished with these judgments so that we can all go back to our respective divisions.
As court pleases. Once again, I thank my Lords.
We shall do that.
Thank you, my Lords.
You're welcome.
My Lords, my Lords, as we have always shown, we are neutral. But my Lords, sincerely, we must thank your Lordships for two things. This is one of the rare occasions we have where everybody, including my boss, Libby, are given too much latitude to do anything we can do here legally. My lords, we must be very grateful to all of you, my lords. My lords, we are grateful. The second thing, sir, my lords, we want your lordships to pray to us so that this analytical mind will come to, not me again, no, we are finished, to the little ones, because the way these things have been analyzed, my lords, some of us are happy that we are not on the bench. I can't do it. Honestly, I cannot do it. Lastly, my lords, we are so grateful that it is a unanimous judgment. And for INEC in particular, my lord, we are happy that all my lords say, INEC, you are right not to have transmitted results electronically. My lords, we are grateful.
All right. Electronic transmission of results.
My lord, on behalf of the second respondent and also our leader, Chief Olanipekun, who is unavoidably absent on account of being out of jurisdiction, we would like to thank my lords for very, very detailed, painstaking, insightful, and also refreshing rulings and judgments. My lord, there are lots to be taken away. Having regards to the volume of the judgment and rulings, it is not unexpected that there will be errors. But I want to confirm that the errors we are talking about are just typographical errors and not anything substantial. Maybe for the benefit of all concerned, that they are typographical errors and not anything substantial that has to do with the substance of the judgment. I take it that way because once your lordship has delivered judgment, your lordship are functious officials.
Yes.
Except to correct typographical errors.
Let me just say,
yes,
that this is common knowledge.
Yes, sir.
That when we say we observe errors
yes,
in the delivery of judgment,
yes, sir.
not errors in the substance of the issues decided, but of course typing errors. And these are what we want to now correct. We can't correct ourselves. After delivering a judgment, we cannot correct ourselves. We cannot correct our errors on law, on the facts. That will be for...
My lord, we find that very comforting. Above all, my lord, like I said, we want to thank my lord for these judgments. A few things to take away in terms of thanking my lord for confirming the identity of Livinus, that Livy and Livinus are the same. And for being consistent to confirm that Muhammad and Muhammad are the same. My Lord, that's being consistent. So we thank my Lord for that. Also, we thank my Lord for letting us know that there is need to tower above sentiments, that cases are decided based on proved facts and evidence and devoid of pre-judgment whatever. My Lord, we thank my Lord for everything. All we can say is that, my Lord, may God just continue to refresh and energize you. Because it's been about almost 8 hours. Almost 9 hours. All of them taken together. Everybody has been able to sit down and look at the whole thing. And I know that it has taken a lot of hours also to prepare. And all we can say that from on this side is to say, thank you and thank you and thank you for being on the side of justice without fear or favor. Lord, we are grateful, sir.
You're welcome. Oh, please say something.
Please, your lordships, ingratitude, they say, is the mother of all evils. I join my colleagues in thanking your lordships. But before I do that, my lord, not because you are not the most important, but because I need to say this, that I thank my learned friends for the petitioners. I've always insisted that we should give leadership to other members of the public whenever we feel aggrieved. Instead of taking to cudgel and guns, we should come to court. My Lord, I commend them for coming to court, and I urge that we should continue to do that. My Lord, I thank your lordships, and I say that in this sacred well of your court, it is this day that your lordships are carrying out a solemn constitutional duty. You have brought all the important petitions to conclusion by handing down a landmark unanimous decision just delivered. I just want to appreciate your lordships, not because the decision has turned out in our favor, but for the tremendous back-breaking work you have had to produce in hearing and deciding this petition. That your lordships plowed on during the court vacation period, when the rest of your brethren were enjoying their well-deserved or well-earned rest, surely calls for commendation to your eminent selves. From the start, your lordship had to bear through needless, inappropriate insinuations from within and outside the courtroom that eventually led to the adjustment in your lordship's personnel that finally heard the case to the conclusion that just happened today. Aside all these, my lords, those who wouldn't give justice a chance to reveal its virtuous hand, in this case resorted to assaults against its just resolution in a largely unrestrained social media, spewing disrespectful conjectures and unreliable commentaries that our homegrown legal and judicial philosophy had over time adjudged as undue interference with the administration of justice and therefore unacceptable. All I'm trying to say, my lord, is that it has truly been a night of long knives. But despite all these indignities, your lordships with stoic fortitude labored through it, all the while breaking your back on several interlocutory proceedings and grueling drudgery of the trial that had all sorts grown into it. I must at this juncture congratulate your lordships on the telling fact that while at it, this court's decision on interlocutory matters, especially the one on the purported INEC server that were challenged in the Supreme Court, were resoundingly affirmed by the Apex Court. This particular fact, my lord, must be seen by all as a credit to the deep learning and experience that aggregate your lordship's judicial worth. Finally, my lord, it is a lesson to be learned from this litigation that the excellent work that your lordships have just accomplished is the court cases that should be transacted, won and lost in courtrooms and not on TV and social media. My lords, we also thank you. You are not owing us. Rather, we are the ones owing you. We thank you for commending us, and I'm happy even if my clients don't pay me. They will pay me, though, and they have been paying. Yes, my lord, the chairman of APC, when we went out, he said, I didn't know that judges are also surgeons. I said, yes, I am happy you are in court. My lords are surgeons. The surgical operation you did was very methodical. I can continue on and on. It is well that this judgment is unanimous. It is well that all the stems, roots, and branches of the case have been refused. We have learned a lot. I wish you well, my lords. I can see that you are old young men, but when you grow old, I pray that, like the glory of sunset, your night will be peaceful. Thank you.
Young men. Well, gentlemen, on a final note, we also like to thank you for all the kind words and commendation from the court. But primarily, we take it as a primary constitutional and national responsibility that we have been called upon to undertake and make sacrifices in our own little way towards the development of this country. And we assure you that we are always ready to do so. And we look forward to meeting all of you at some other fora. Thank you very much. Everyone ready? The court will now rise.
Court.
Come on, please.